Okay, let me call roll. Mr. Watkins,
Here.
Mrs. Stewart,
Here.
Mr. Blofus,
Hey, Brundage, I'm here.
Here.
Mr. Alexander,
Here.
Mr. Brewer,
Here.
Ms. Brundage,
I'm here.
Mr. Eldridge, Mr. Hoss,
Here.
Mr. Roberts,
Here.
Mr. Royston,
Here.
Dr. Spiceland.
Here.
We have one announcement. This meeting was properly noticed by having the agenda posted on the board's website on Wednesday, March 19th, 2014. And now, Mr. Whitaker, if you will take off.
Thank you, Mr. Crocker. Before I read the determination of necessity for the record, just need to let the board members know that because this is an electronic meeting, all votes will need to be done by roll call vote. Voice votes will not suffice, so that everybody knows who voted how on the various matters before the board. At this time, I'll read the determination of necessity, and at the conclusion of this statement, I will need a vote by the board to approve the determination of necessity, at which time the board may begin its deliberations on the Shepherd Church matter. Tennessee Code Annotated, Section 8-44-108 requires, number one, that a governing body which conducts a meeting electronically and without a physical quorum present at the location of the meeting make a determination of necessity as defined by TCA 8-44-108, subsection A3, regarding the meeting. Number two, that such determination and the facts and circumstances upon which it was based must be included in the minutes of the meeting. And number three, that the governing body must file the determination of necessity with the Office of the Secretary of State no later than 2 working days after the meeting. The operation of the Tennessee State Board of Accountancy is governed by the Tennessee Accountancy Act of 1998, which is located at Tennessee Code Annotated 62-1-101 and subsequent sections. The board determined that there is a necessity for a board meeting via electronic means prior to its next regularly scheduled meeting on May 2nd, 2014. The facts and circumstances supporting the necessity of today's meeting by the board, April 4th, 2014, are as follows. Number one, necessity exists for this meeting to be held electronically because the members of the board participating in the meeting are spread geographically throughout the state of Tennessee. Further, the participating board members are unable to be physically present for this board meeting due to a relatively short notice period of approximately 2 weeks. And because requiring the board members, a majority of whom are CPAs from other areas of the state, to travel great distances during the height of tax season would impose a substantial hardship on those board members. Number two, TCA 62-1-108 and the rules promulgated under the Act set forth the requirements for licensure as a CPA firm in the state of Tennessee and the circumstances under which the board may issue CPA firm permits, including the regulation of the name of a CPA firm. Number three, at the board's January 2014 meeting, which was held on January 31st, 2014, the board considered a request for a name change made by Jeff Shepherd, CPA, PLLC. If approved, the firm's name would be changed from Jeff Shepherd, CPA, PLLC to Church Audit and Financial Solutions, PLLC. At the board's January 2014 meeting, the board voted to defer consideration of this name change request until the board's May 2014 meeting in order to allow Mr. Jeff Shepherd, the resident manager of Jeff Shepherd CPA, PLLC, to appear before the board regarding his firm's name change request. Number four, due to an administrative error, a CPA firm permit was mistakenly issued in the name of Church Audit and Financial Solutions, PLLC, on or about February 10th, 2014, without board authority or approval. Although the mistake was caught quickly, Church Audit and Financial Solutions, PLLC, or Jeff Shepherd, CPA, PLLC, had already begun the process of changing its legal name and advertising materials to reflect its new name and had incurred expenses in doing so. Number five, necessity exists for this meeting for the board to determine whether the request by Jeff Shepherd, CPA, PLLC, to change its firm name to Church Audit and Financial Solutions, PLLC, should be approved or denied as soon as possible in order to prevent any further expense or delay to Mr. Shepard's CPA firm as a result of the mistaken issuance of a CPA firm permit in the name of Church Audit and Financial Solutions, PLLC, without board authority or approval. This concludes the statement of necessity. And at this time, I would request that the board do a roll call vote to approve the statement of necessity, and I'll have Mark call the roll, and each board member can respond with their vote accordingly.
Mr. Watkins,
Yes.
Mr. Stewart,
Here.
Mr. Blofus,
Yes.
Mr. Alexander,
Yes.
Mr. Brewer,
Yes.
Ms. Brundage,
Yes.
Mr. Eldridge, Mr. Hoss,
Yes.
Mr. Roberts,
Yes.
Mr. Royston,
Yes.
Dr. Spiceland.
Yes.
Thank you, Mr. Chairman. You have a unanimous vote to approve the necessity of this meeting. I will be responsible for filing the determination of necessity letter with the Secretary of State no later than 2 working days from today, so the board doesn't have to worry about that. And at this time, I will turn the meeting back over to Mr. Crocker and Chairman Watkins to begin the board's discussion and deliberation of the name change matter on the agenda today.
Okay. Hey, Mark, do you want to just go ahead and give a very short, I guess, the statement of or that whatever we just passed kind of describes the way. Will you give us just a little bit of background? What?
That's kind of broken up, Trey. I didn't hear. You just want a background summary?
Yeah, just a brief synopsis of how we got here and kind of why we're doing what we're doing today. Or maybe I need to answer that, I guess.
Well, the brief synopsis is, as noted in the determination of necessity, through an administrative error in the office, a permit was issued to Church Audit and Financial Solutions to operate under that name. They proceeded to begin operations. We caught it rather quickly, but by then the board investigator had visited. The day after the board investigator visited, Mr. Shepard's attorneys contacted the assistant commissioner and legal counsel and advised that they thought something needed to be done, that they were going to continue to operate as Church Audit Financial Solutions until further notice. That's where we are. That's the necessity for the meeting. We have got to decide whether we're going to allow them to operate or not.
Okay. And I think in the last meeting, some of the members had objected to doing so without further investigation, and maybe even the opportunity to speak with the individual that was applying for the permit. I don't think the individual is on the call today, although he was invited, correct?
That's correct.
And did Mr. Mills ever was he able to retrieve any information that board members had requested, or did that get shut down as a result of the error?
Mr. Chairman, this is Mr. Whitaker. As I understand it, I had an opportunity to talk to Mark and review some of the findings about documentation and the like that the board had requested regarding this matter, and it's my understanding that documentation was emailed out to each individual board member.
Okay, I've got my packet here, yeah.
And so the documents in that packet are what we have for the board to consider at this time. And, you know, the board can and should look at those documents and weigh them accordingly. And also, the board may give any weight or no weight as it deems necessary to Mr. Shepard and or his attorney declining to show up. They were invited, but by letter essentially declined to do so, stating that they were relying on past board precedent in approving similar name changes, and that they would simply allow this meeting to happen without them present and reserve their legal rights and remedies and so on and so forth in the event that it didn't go the way they wanted it.
I noticed in the, this is Mr. Royston, the Secretary of State's audit records indicate that these amendments were filed. The amendment to change the name was filed December the 17th, which is prior to board action. And the name was actually set up on August the 7th of 13, which is prior to board action. So I don't know what kind of claim he has. Seems like the horse was already out of the barn before the board acted on it.
Well, Mr. Royston, to that point, I don't really think the board has any jurisdiction to tell somebody what they can or can't do vis-a-vis selecting a business name through the Secretary of State's office. So at least in theory, a person or individual or company could obtain any name that the SOS tells them is available through their office if they pay the appropriate fee and submit the right paperwork. But
I would agree with you, but they told us in their letters that they sent to us that they went to great expense to change the name and file the change of name from. They'd already gone in and set up church audit and then changed it to Jeff Separate back in December.
And they, Mr. Royston, this is Mr. Crocker.
Right.
They changed it back when I told them I would not approve the name Church Audit and Financial Solutions. That's when they went back and changed it to Jeff Shepard.
Okay. So, but what kind of expense have they gone to in the 2 weeks that they're trying to allege that they've gone to? The great expense to change the name, the $20 fee to change it back.
They're alleging printing of stationery and business cards, setting up a website, that type of thing.
And it should also be noted that, at least after my review of the most recent letter from Mr. Shepard's counsel, that there was no itemization of these claimed expenses. I mean, if it does appear there somewhere and Mark has a copy of something that I don't have, he can certainly share it with the board, but I didn't see anything like that. So the board is somewhat left to wonder and speculate potentially on what exactly those expenses might be beyond the generic description and exactly to how much expense Mr. Shepard and his counsel have gone to in that regard. But those would be questions that could be answered had they elected to participate in today's call.
This is Casey Stewart, and I want to just make a few comments and maybe ask some questions here. I did review a couple of times this package of information that was furnished, and I guess first off I would like to say, had we been looking at this in our earlier meeting, including all the complaints against Michael Chitwood and the application for firm licensure and just everything that's in the package, I would not have voted to approve this name change. I would say that another way, I would vote not to approve it until we receive further information. I also think in looking at the transcript that was sent out in this package and looking particularly at the comments of Henry Hoss, I think Henry was exactly right, and I think his comments were very appropriate in causing us to consider this thing further. Some questions I have, the non-licensee owners that are on the firm permit application, I could not help but notice that one of those is the name of Kamara Chitwood, and I wonder what her relationship might be to Michael Chitwood. If she is a relative, if she works in the firm. Also, Jennifer Helton, I wonder, does she work for Michael Chitwood at present, or does she work for Jeff Shepard in this CPA firm? Some other questions I have is just the biographical information that was provided on Jeff Shepard is very brief. We did not have this earlier, I do not believe, but it's simply a one-sentence statement in there that says at least 75% of Jeff's practice consists of representation of churches and religious organizations. And his practice was only started in December of 2013. He, as I understand it, still works for Michael Chitwood, which begs a question when you look at the substance of the proposed ownership of this firm. Is Michael Chitwood, in fact, the individual that is going to control and dominate in substance how the firm practices and what it does? Those are just some of the concerns on my mind, and I do understand that there's I took it to be a legal threat in the March 27th letter from Gearheiser, Peters, Elliott, and Cannon, where in the penultimate paragraph they indicate they are reserving all legal and equitable remedies available to the firm regarding this issue in the event we have an unfavorable determination. So let me stop and listen to some other people, I guess.
I'd like to just follow up a little bit on Casey's comment concerning Jeff Shepard. If you Google the name Jeff Shepard CPA, what you'll get is his resume, and he's identified as a senior accountant at CPA firm, Chattanooga, Tennessee, and then it goes on to say that he's a senior accountant, CPA firm, February 2013 to present. And I assume he's talking about Jeff Shepard CPA, but I'm not sure why he would call himself a senior tax accountant at that firm. Prior to that, he was a controller, assistant vice president of finance at Dalton Utilities. And that lasted from October 2009 to August 2012. And then prior to that, he was a CPA partner at a firm called Smitherman and Shepard from 1996 to July 2007. In his entire resume that you get when you Google his name, nowhere in here does it say that he does church audits, or does his practice lend itself to consulting with churches or ministries or nonprofit organizations. It mentions that he's got he's obtained an insurance and security licenses so that he can help his clients meet their financial goals. But outside of that, it doesn't say anything at all about any kind of expertise dealing with churches or ministries.
Hello?
Hello.
Okay. Want to make sure there's still somebody out there.
Yeah, we're here.
Okay. I'm going to ask Don to address the issue in regard to the personnel that are listed on the ownership sheet.
Well, Michael Chitwood, of course, is the owner of Chitwood and Chitwood. Jennifer Helton is an employee of Chitwood and Chitwood, and has thank you. Has a PTIN number with the Internal Revenue Service for filing tax returns under the firm name Chitwood and Chitwood. Camara Chitwood, as best I can tell, appears to be Michael Chitwood's daughter-in-law. She was, I don't want to get into a lot of what I found, but that's what I can determine as closely as possible. She is his daughter-in-law or ex-daughter-in-law and does not appear to work for the firm at all.
Mr. Mills, this is Gabe Roberts. I got a clarification question. In reviewing the documents, it wasn't entirely clear to me on the initial application for the Jeff P. Shepard CPA PLLC firm, was he the only listed person with ownership, or were these other individuals also listed as non-licensee owners in that firm?
Yes, those people that I just mentioned are all non-licensee owners. Their percentages vary from, 19-20%. But Mr. Shepard is mentioned as a 51% owner. Mr. Chitwood at 27, Ms. Helton at 20, and Camara Chitwood, I'm sorry, I'm reading the wrong column. 10.5% for Mr. Chitwood, 24.5% for Ms. Helton, and 5% for Camara Chitwood. And
But is that for the application of the firm in the name of Jeff T. Shepard, or is that the application for the firm in the name of Church Audit Financial Services?
Gabe, this is Mark, and that is for the initial application for Jeff Shepard CPA.
Okay, that's what wasn't clear to me. Okay, thank you. Mark, this is Gabe again. Can I ask one more question about this?
Sure.
Looking in the relevant portion of the code, I believe it's 62.1.108. C1 talks about how firms can have non-licensees or non-Tennessee licensees as owners, but they can't control the firm. And when I was looking through the initial application, I saw the various questions that looked to be addressing a separate portion of this statute. I believe the questions on the firm application were actually addressing sections D1 through 3. But under C1, what type of information do we look at, does the board look at usually when it gets an application for a firm that includes ownership of non-Tennessee licensees? Is that something that comes out in investigation, or is it something that you have casual conversation about, or is there a form that I didn't see, or maybe I missed something on the form you provided us that actually asks about agreements for control? For example, in that portion of the statute I talked about, at the end it says that the control may not be relinquished by contract through the issuance of a minority veto rights or otherwise. So are there any questions that are asked about management agreements or anything like that that perhaps minority owners that don't hold licensees may have, so they actually control the firm despite the fact that they don't have a majority interest?
No, if you'll look on the firm ownership form, Gabe, and this is in one of your packets, but we do ask for the non-CPA owners, we ask for their percentage of work time, how much they own of the firm, and what their voting rights are.
Okay.
So the voting rights is what we key to as far as who's going to control it.
Okay.
And in this case, the minority voting rights came to 49%. Mr. Shepard had 51%.
Right.
This is Mr. Whitaker. I apologize for chiming in here, but if I may interject about what it appears that Mr. Roberts is bringing up. Gabe, is it my understanding that you might be interested in having some kind of statement maybe added to the forms, if we can make that happen, to have an applicant affirmatively attest to their compliance with 62.1.108C1 about no side agreements or minority veto rights? I mean, because
I think as a general matter, it might be worth revisiting. With respect to this case, I think it's just a little bit why it would be nice to be able to have Mr. Shepard with us, because that's a question that I would ask, is are there any contracts or any arrangements between you or the firm and the non-licensee owners that would give them effective control despite the fact that they only have a minority interest? So for me to make a well-informed vote, I would like to know the answer to that question.
This is Casey Stewart, and I would also like to point out that Section D2 of that same section provides that all non-licensee owners are active individual participants in the CPA firm or affiliated entities. And concern again here is that these non-licensee owners all work for Michael Chitwood.
I was thinking that, Casey, the application that I looked at said that Michael Chitwood would spend 27% of his time working for the Church Audit and Financial Solutions PLLC, and this lady Jennifer Helton would spend about 20% of her time, and then this Karma Chitwood would spend zero time.
Which means that would not comply or meet the requirements of Section D2.
Right.
Am I reading that right?
That's correct.
Yeah. I would be very, in spite of the percentages of ownerships and everything, I would just be very concerned about Mr. Chitwood or the non-CPAs having the ability to influence a decision on an audit opinion. That would concern me quite a bit.
And Mr. Haas, the next time you speak, please identify yourself for the record, but also, if you wouldn't mind elaborating as to why you would be concerned about that issue specifically, if you could.
Well, sometimes in firms, when you have issues come up in an audit, you pull together several people to help work through the process of dealing with problems, dealing with issues, and dealing with the technicalities of the issue. And in this case, if Mr. Shepard pulls in the non-CPAs to assist in dealing with the technicalities of some issue, they may provide an undue influence on how that problem is worked out. And they're not qualified to do that.
Thank you, Mr. Haas.
Mr. Crocker, this is Gabe. Did someone just dial in a few minutes ago?
Mr. Eldridge, are you there?
Yes.
Okay.
Sorry, I got tied up in a meeting.
Thanks, Stephen.
I was trying to sneak in.
Sorry to call you out, Stephen.
God, thanks.
I would like to just mention that the way this thing's structured and the way it's set up, it appears to me that there's a very big conflict of interest here in the way this firm is going to operate. Church Audit and Financial Solutions. It seems like that Mr. Chitwood has got a major conflict of interest in what services he's providing out of Chitwood and Chitwood, and then his involvement in the decision making of the services being provided out of Church Audit.
I would agree with that observation. This is Bill Bloffus.
I guess the question I've got is, this is Trey Watkins, is do we have enough information to actually make this decision today? Because it sounds like we've got, I guess it was Mr. Stewart that said that it was that a non-member that we're not going to spend any time in the firm and violated the rule. Is that correct?
Mr. Watkins, can you please repeat your question, or it's kind of breaking up a little bit on our end?
Oh, sorry. I guess my question is, are we saying that the application is deficient because of the minority owner not working in the business?
Well, that, Mr. Watkins, that's certainly a determination for the board to make. On its face, it appears the answer to that question would probably be yes, but the ultimate decision there is for the board to make. However, a kind of meet in the middle option that the board may wish to consider and is not required to, but the board has taken the unusual step based on the circumstances of having this interim meeting to do its consideration, and has found not only that it has additional questions, but also that there appears to be a defect on the face of the application. So a potential middle of the road solution might be for, at this time, for the board to deny the application before it, based on the section D2 and Camara Chitwood's professed 0% of work time, but provide Mr. Shepard's firm leave to resubmit an application for a name change if it so chooses, which would in turn potentially give the board and or the staff the additional time between now and the May meeting to try to get answers to the questions that have been presented today.
Okay. Do I have anybody that would like to make a motion to that effect, or do you want to keep discussing the issue?
Chris, this is Stephen Eldridge. I've got one question.
Okay.
If we deny the application, though, would that not forego the any follow-up stuff? I mean, why would we be following up if we've denied an application to go back and get clarification for things we denied them for?
Well, they would have to send a corrected application in for a firm permit, correct?
That's correct, Mr. Watkins.
They may refile, and at that time we can then deal with these questions.
Okay. Okay.
This is Henry. I'd like to point out, I think Mr. Crocker mentioned early on that both Mr. Shepard and his attorney were invited to come and participate in this meeting, and they chose not to do so.
Did we get to Stephen Eldridge? Did we get any reasoning why they declined, or did they just decline and that was it?
Well, Mr. Eldridge, if you look in your packet, I believe Mr. Crocker included the most recent letter from Gearheiser Peters dated March 27th, in which they stated that they would simply rely on the board's prior precedent in similar matters, and because of that, they essentially would not be here today and would allow the board to make its decision based on that and the previously submitted documents. So that is a decision that was theirs and only theirs to make, and the board may make of that whatever it wishes to or not.
Okay. I mean, I saw the letter. I just didn't know if there's anything else, more specific reasoning why they didn't show up.
If there is, it hasn't been shared with me, and I don't believe it has with Mr. Crocker either. So.
Okay. Thanks.
Mr. Chairman, this is Mr. Royston. I'd make a motion that.
Mr. Royston, this is Gabe. Can I talk to you one more comment before you? Sure. Mr. Whitaker, forgive me for putting you on the spot, but I guess I'd like to try to frame the issues. It looks like there might be two separate issues here. One is whether the name might be considered misleading or deceptive, and the second is an insufficient application. Would you agree with that?
I actually would agree with that. As it turns out, the defective application issue wasn't thoroughly brought to light until this meeting today. So, but I would say that as a general matter, I agree with you, and so the board, if that is the issue being framed, then the board may still yet choose to defer making a decision as to the name change, because if the board makes a finding that the application before it requesting that name change is defective and insufficient on its face, then it need not reach the question today of whether to grant the name change or not. Does that make sense?
It does. Can I ask you two other quick follow-ups?
Please.
And then obviously open the floor to my fellow board members for their follow-up. Looking in the rules 0020-03-.15, subsection 3, it says the board may disapprove of the use of any fictitious name falls within one of the prohibitions listed in paragraph 1 of this rule, or if it determines after notice and hearing that the trade name is deceptive. So am I reading this correctly to say that even after a fictitious name may have been approved, whether by administrative error or not, that the board has the authority to go back and review those names and therefore act properly and legally in determining that one may be deceptive? Is that a fair interpretation of that rule?
I think it is subject to the caveat that I would somewhat take issue with the characterizations, some of them that are kind of implied in Mr. Shepard's counsel's letter, because all of their correspondence seems to implicitly claim some right to this name change that never existed, because the administrative error was exactly that. The board staff operates pursuant to board authority, and that includes the issuance of firm permits. So, I would argue that the firm permit that was sent out the door that Mr. Shepard had with the church audit and so on name on it is actually a legal nullity, because although it may have been produced on paper, the underlying necessity and requirements of board authority and action that should have led to that never happened. Does that make sense?
It does. I think that's a fair argument and a good argument. But even in spite of that, even if that wasn't the case, would it be fair to read number 3, as I just said, that even after even if an approval was then deemed to have been given, doesn't the board, under the authority of this rule, have the opportunity to go back after the fact and revisit a name to see if it's deceptive or not?
It appears that is, I would say it's a reasonable but potentially not the only interpretation of that rule. One being that as a purely legal matter, it determines after notice in a hearing. It doesn't appear to specify that notice in a hearing has to take place before the initial issuance or denial decision has been made. It appears to leave open the possibility that it could happen at any time. However, as a practical, functional matter, it could lead to some inconvenience and other issues of the type claimed by Mr. Shepard and his counsel, were the board to say, on the one hand, we're going to go ahead and issue this license, but then do notice in a hearing later and come back and say, oh no, now it's fictitious. So I think it could go either way, and there are arguments to be made in either direction, but it's certainly one reasonable path to argue.
Thank you.
Mr. Royston, were you going to make a motion?
If we're through with that, I would make the motion that we deny the name change application as a result of a defective application, and affirm the original board, if this is proper. The original board meeting said that it would be put on hold till we got the rest of the information, and we want to affirm that fact, that it was never approved as part of this motion. However, the proper term is, I think both of them need to be in there, that we're affirming the fact that it was nothing but a administrative error.
Okay, I have a motion on the floor. Is there a second, Mr. Roy?
Chairman Watkins, this is Gabe Roberts. May I make one friendly amendment to that motion?
You certainly may. Please clean it up.
Well, I'll just maybe add, in addition to the defective application, that there's still questions as to whether or not the name is deceptive, because we have not been able to ask the questions that have been proposed on this call to Mr. Shepard.
Good point.
And just I'm not offering a friendly amendment because I'm not on the board, but I am asking for clarification for the purposes of the motion as to whether or not, subsequent to the denial for the defective application, that the board still wishes to potentially consider this matter again at the May meeting if Mr. Shepard and or his counsel wish to attempt to resubmit a revised application and then potentially have answers to the questions that the board has brought up today.
My personal feeling, as having made the motion, is that we would be obligated to look at any complete application that meets the qualifications. At this point, we're denying this one because it's a defective application primarily.
It seems to me, this is Henry, it seems to me it doesn't really matter if it's a May meeting or the July meeting. Whenever if and when they ever decide to submit a new application, then we'll reconsider it.
Fair point, Mr. Haas and Mr. Royston. Thank you.
Okay, so we've got a motion to deny the permit. We have can we get a second?
Second, this is Charlene.
Okay, Starling, a second is the motion.
Hey, this is office.
Could
the
I
motion
ask?
be
Go ahead, Mr. Hoss. Is that you?
Yes, this is Henry. I was just going to ask if somebody has attempted to write down that motion with the change or amendment to the motion to see what we ended up with.
Okay.
I believe the motion on the floor is to deny the application itself based on the defect pointed out under Section D2 of the statute, and to defer consideration to approve or deny the name change pending receipt, if ever, of a revised or new application from Mr. Shepard and his counsel.
Okay.
very good? Thanks.
This is Mr. Royston. I would agree with that interpretation or that writing of it.
Okay. Charlene, you're still good with it, with the second?
Yes, yes, I am.
Okay. All right, so I have a motion and I have a second motion. There is further discussion.
Mr. Watkins, can you please repeat the last part? You broke up again. I'm sorry.
I'm sorry. We have a proper motion. We have a second on the motion. Is there any discussion on the matter? It doesn't sound like there's any further discussion. I guess y'all want to start with a roll call vote, please?
Okay, I'll call the roll. Mr. Watkins,
Yes.
Mr. Stewart,
Yes.
Mr. Blofus,
Yes.
Mr. Alexander,
Yes.
Mr. Brewer,
Yes.
Ms. Brundage,
Yes.
Mr. Eldridge,
Yes.
Mr. Hoss,
Yes.
Mr. Roberts,
Yes.
Mr. Royston,
Yes.
Dr. Spiceland.
Yes.
Okay, Mr. Chairman, it looks like you have a unanimous vote on that.
Okay. So I guess you'll notify them of the vote and describe the situation to them as to why it was denied.
Yes, sir. We will.
They can always resubmit another application later on.
Yes, sir. We will get that out.
Okay. Sorry to pull everybody in today, but felt like we needed to get this handled. So, sorry to take up an hour of your day during tax season. But I think that's it. I guess with that, adjourn the meeting.
Mr. Chairman, again, since it's electronic, let's do one more roll call vote to adjourn. I apologize for the formality, but better be safe than sorry.
So do I have a motion to adjourn?
So moved.
moved.
This is Stacy Stewart. I move that we adjourn.
Okay. Is there a second?
This is Henry. I second.
Okay.
All right, Mr. Watkins,
Yes.
Mr. Stewart,
Yes.
Mr. Blofus,
Yes.
Mr. Alexander,
Yes.
Mr. Brewer,
Yes.
Ms. Brundage,
Yes.
Mr. Eldridge,
Yes.
Mr. Hoss,
Yes.
Mr. Roberts,
Yes.
Mr. Royston,
Yes.
Dr. Spiceland.
Yes.
All right, folks, that's it.
Thank you, Mark.
Thank you so much.
Thank you.
Thank you very much.
How do we hang up?